All right.
Leila's absent.
We're good.
Right. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Script, there's nothing in the script, right? Any topics from the floor? No one's on the floor. What do you guys think of the minutes from the last meeting?
Well, I tried. I really did, until 7:40.
I move that we, well, unless there's comment.
Well, before we move,
Yeah.
I had a comment. I was wondering why the times in here were just generic times and not the times of the actual hearing. It's 7:05, the first one, and then it says the subdivision started at 7:30. Well, I know it didn't start at 7:30. 10:30.
How it always is on
Yeah.
the agenda.
That's what I was
Here's
wondering.
what time they're scheduled for.
But then at the very, very end, it says we adjourned at, 12:30. Why do we even announce the time is now blah, blah, blah?
It's so that on the video portion that we put on YouTube is at that time. So when you go back and you click on the video, in the middle of the
Yeah.
video, the time, and for a timestamp on the video.
Why don't we have that on the written minutes?
It's based on the agenda, the scheduled time.
See that, but,
Yeah.
The agenda or the minutes should reflect.
yeah. Just because we always do it, no, no answer to my why.
I mean, we could add a sentence. I still think that the way our minute software works is it pulls from the agenda and puts it in the minutes. So it would just create more work for Christina to have to go in and edit each subheading for each hearing.
Oh, so it's not inputted.
No, that's pulling from
Okay.
the agenda and creating the minutes. I have that right? That's how the.
Yeah.
minutes work, yeah.
I mean, we could put a sentence in there that says meeting actually started at.
Or just that the public hearing was
Public hearing
opened at
this
this
time.
certain time.
It just seems like that's
Yeah.
what we're actually voting on, the minutes as they occur, but. Right,
Yeah, that could be confusing in the future, looking back.
Yeah.
They sure talked about a lot in 30-minute span.
yeah, boy.
Yeah.
So what, the last thing took,
Yeah,
4 hours?
The solution would just be to say like Chair Carey open the hearing at add a sentence at the beginning of each one.
Just, that was the only thing I had to say about the minutes. So
Something that would indicate true time.
good summaries, not all the words that were spoken. Your book. Motion to approve.
Again,
All in favor?
Stating.
Was 3 enough?
I think it is.
Yeah.
If it isn't, you
Russ
could
is
go.
here.
This is-
I'm sorry.
Don't lock him out.
Did you,
No, he's here.
did you vote? I didn't see you up there, sorry.
I did,
What did you say? Say aye? Okay,
Yes.
Thank you.
Thanks, Russ.
Sorry for ignoring you.
no worries.
All right. So next thing, discussion item. Architectural design guidelines review for 230 Strand Street, Columbia.
Great, so I'll cover this one. So this is a pretty simple proposal, and it's proposals like these that make me a little bit sad that our code doesn't have any sort of distinction between, significant architectural change and something like this. But here we are. We also have Brendan on Zoom here, who can answer any questions. He's representing the county as their architect. He's waving, you guys can see him here.
Yeah.
But I'll just briefly talk about the proposal and then see if there's questions and then see if Brendan wants to add anything that I've missed. But the short is the county wants to replace this door on the left here with an automated sliding door. And replace this floor to ceiling window that's currently covered up with this security grate with a new door for their mailroom access. And then they also want to install a USPS parcel box kind of in this area between the two doors. So that's where we are. It's the river side of the courthouse, so it's not the front of the building. Our historic district identifies this as a non-contributing structure. So I feel like there's not a lot of visual sensitivity to this building as there would be for the historic courthouse next door. So the memo talks a little bit about what guidelines are relevant in this case. You know, we're messing with doors and windows, which would normally be a very sensitive topic if it were a contributing historic structure. But in this case, they're pretty much replacing a door that's non-functional with something that looks fairly similar, is automated and will improve access. And then they're replacing a window that is not really contributing to the rest of the building. You know, the majority of the windows are above and on the sides, floor to ceiling. So this is kind of an odd placed window. And then the USPS box, you know, they're painting that to match the color of the facade, so it won't stick out like a sore thumb. I think they chose a bronze color, so there's some images of what it would look like. And then they've circled the color at the bottom of that. I'll this right side up here. So that would kind of match the facade. That's really all I had. I feel like, you know, they're meeting the intent of the code. I don't think there's anything really concerning here.
Isn't it health downstairs?
I believe it is public health. Brendan knows a little bit more about the.
Well, I'm just
interior.
thinking as far as the doors.
Yeah.
And I can defer to Jennifer on the historic part of this, but wheelchairs going in and out, because we have them going in and out the front of it. This side, the main
Yeah.
entrance.
Yeah,
But the sliding glass door would be preferable.
yeah, it's a huge upgrade and
Oh, yeah,
touchless too. So I think it makes a lot of sense with COVID and.
Well, that's what I'm saying.
Yep.
Yeah.
Good point.
My only question in it, and I don't really see a problem with it, is this non-contributing because at the time of the inventory, it wasn't 50 years old yet?
It was, yeah, you're right. The nomination forms were done in the 80s. I think they have a number of factors that go into that. I don't think age of the structure is the only one.
That would be significant architecture or
Yeah,
something happening there. I don't have a problem because it's on the back of the building.
It's on the back of the building, is my thought.
It makes sense.
Yeah.
I think it's just improving. Any other questions? Brendan, did I miss anything here?
No, thank you, Jenny. I think you more or less covered it. It is public health that's inside. And then there's also a small mail receiving room associated with the proposed renovation, which is the reason for this parcel box that's on the screen currently.
So we don't have a building permit yet, but when we get getting this process out of the way, we'll just make the building permit review faster. And so that's why we're over here.
Well, anyone that comes in the main entrance is using the elevator to get down. And literally, it's easier if, well, when I'm there for information, if we press the button so that you don't have to mess with it, with wheelchairs. So I'm all for it.
What we need to do is,
I think we need a recommendation.
Only that we
Yes.
allow what they're
wait
requesting.
a second. All in favor?
Aye.
Can we get okay, Russ voted aye as well. Okay,
Yeah.
great.
Thank you, Russ.
All right, thanks, Brendan. Enjoy your family.
All right, nice to meet you all. Thanks so much for your time.
Thank you. Order and conduct of
Yeah, here.
public hearing.
family in town, so I was like, attend on Zoom, we don't have to come all the way down here.
Mhm.
So I'm tackling this as well. So in your packet, there is an order of conduct page document that Christina puts in the back room anytime we have public hearings scheduled. And I'm proposing that we add a sentence in there that talks about a time duration for anyone that isn't the applicant. I recently attended planning commissioner training that was hosted by DLCD and the Oregon Planning Association, and asked the question, how common is it to have time limitations? And they said it's actually uncommon to not have a time duration.
Right.
And so I just wanted to put it to this group and see if there are thoughts. I think it would help prevent people from getting off topic if we limited the duration. It kind of makes them organize their thoughts a little bit more. And the commission meeting, the training, they said no good decision was ever made at 1 a.m. in the morning. And literally that's when our meeting ended. So I feel like this
We're the
will,
exception.
yeah.
It's that good.
But for staff's mental well-being and ability to stay, coherent enough to provide guidance, I think it's important that we just don't run that long.
I thought a lot about this, and I don't feel good about necessarily that it went to 1 o'clock in the morning, like, if I was the applicant, I may have requested, and I don't know what the procedure is, but it seemed like we were all getting tired, and maybe the deliberation would have gone longer if it wasn't 1 o'clock in the morning.
Sure.
Affect the decisions, so I'm all for the limitation.
I had Christina do a quick breakdown of the 2 hearings we had that night, and 41% of our testimony went over 5 minutes. So I think it could have significantly cut back on the testimony if we had a 5-minute duration. One of the testimony went 20 minutes long. 2 of them that night went over 10 minutes long. So I just feel like that's so excessive for public testimony that for the most part is like emotionally driven and not to the criteria. I want to make sure people are heard. That's not the intent of the duration. It's just, like you said, to be
It's
able
fair to
to,
the applicant that we limit other people's.
yeah.
Right.
Is that gonna be a hold fast, 5 minutes you're done? Or you-
So-
Well, that's up to the chair.
Yeah, so at council, they use this for visitor comments. I can get better at using it. But basically it just beeps and it would be up to the chair to say, can you wrap up your,
Just about,
Right.
yeah, and you can extend their time if they're providing relevant testimony, like if it's a variance and it's only affecting this property owner and you want to ask them more questions, you as the chair can do that.
I like having a time so I can stop it. It's just.
It lets you assess the
But
validity
it's
of
not a 5-minute limit on the applicant.
That's right. It would just, and the way this is written, it just says testimony from those who are not the applicant shall be limited to 5 minutes per
We
person.
can save that.
It's on the back of, let's see, is that page 1 or 2? Page
On the
2,
back, yeah.
yeah,
Oh, we sure, red.
Yeah.
yeah. So it would just be added to the conduct of the hearing section,
Yes.
and it's consistent with council. So that's what I like about it too. It's not confusing.
Use that.
Yeah, we do.
Yeah, I'll have to get a quick rundown of how do you do it, but if you just set it for 5 minutes, you just keep hitting start and stop.
I could tell. You have about a minute.
Well, and they can look at it, it's really visible, so they can, usually people are good at like looking over to see how much time they have left. The other thing I would say, we can always change this again, you can also have 3 minutes, I mean, if it's a really packed hearing.
Yeah.
You can set whatever you want. I mean, when you're required to deliberate in public, you don't have to accept any comment, and the council doesn't either. I mean, that is something that can, I think, well, maybe it might be different for the quasi judicial.
Yeah, we have to, yeah.
Well, okay, so, sorry. So anyway, with the city council, I mean, 5 is really generous, so if you accept.
It really seems effective though. I mean, attending and watching city council meetings, People are watching that.
Yes.
timer. They're-
Yeah.
And they have to organize their thoughts, which is what you would expect of an applicant to do. You know, you're not gonna just want them to ramble on.
And I'll explain it, not to limit them and stuff, but
Well, you don't get into the
Make sure that-
emotional thing too.
those people need to have time to do it, so it doesn't run, like.
So this is something we can implement as soon as next meeting, if we're all in favor of adding it to to this handout.
Well, I have
You
one
want a
comment.
motion and a vote on it?
No, just.
I want one comment on this before we vote or head nod.
He wants to be the exception.
I
Except
do.
for,
I think it should say may be limited to 5 minutes per person.
Instead of shall.
Right. Because then if somebody goes over,
that's true.
then, and it's allowed, then nobody can then later say that person was allowed to go more,
I see,
and I
try to
wasn't.
make it,
That's right.
yeah.
And so then, so it just allows some flexibility to the person. But we could say, hey, look, you're going to be limited to 5 minutes, and then depending on how it's going,
Yeah,
actually extended.
I think that's fair. There's some shall statements in here, but there's also a may statement, so yeah, I think that makes sense. This was also a clarification that I wasn't sure about, but you can ask them as many questions as you'd like too, as the commission, and the conduct of the hearing rules clarify that. It just says, planning commission or city council members may question or cross-examine any person who testifies. So that's sort of spread out in there. But yeah, I can change the word shall to may.
If everybody's okay with it, I think
Do you want
there's a
may
good reason
any
for that.
other places?
Yeah, and I'm willing to
I mean,
head
you
nod
want-
on that with the
Okay.
may.
Well, I know, but do you want it down there where it says no person shall testify? Do you want may testify?
Well, shall testify without first receiving. No.
No, this is,
No,
this
that's-
is.
No, I'm just asking you.
Yeah, okay, you're asking me, so.
Yeah, just all the
No,
shall.
I think that anybody testifying needs to be recognized before they testify, that's for sure.
Right.
Yeah, otherwise it'd be anarchy in the hearing.
You can just speak whenever you want.
Yeah, but we get done
Yeah,
faster,
that
if we all
over.
came up at once.
Okay, so sounds pretty
Yes.
good.
Yeah,
Russ?
yeah.
Were you cool with that?
I do agree.
Okay, awesome.
Good timing to ask for it. We were all over that last night.
I know, I was like, we are running with this momentum. No, we
Yes.
don't need a motion. Sorry.
Are
go
we
ahead.
done on this subject?
Yes. Yes.
Because I had a couple of other observations about the conduct of hearings, if you're done with this topic. Can I say something about it?
Sure.
Okay, so one of the things that, we did have a lengthy hearing the last time, and so a couple of things that, first of all, I learned a great deal in the seminar that Jenny, Jennifer and I attended, and I think if you can get a recording of it and see it, I think it's very helpful. There was a lot of discussions about ethics and conduct of hearing. One thing that came up that I asked in particular was about if we have a multi-decision topic, like we have to rule on several things. Can we hear all the evidence at once? And the expert that was there, who was this brilliant woman, attorney from somewhere, I don't know where she was from. She said, yeah, we can do that. And so that was something that we had discussed at the beginning, whether we should compartmentalize the hearings or hear all the testimony. So that's one thing in the future we can think about, is if we have factual things that overlap, we can hear all the facts at once, then go through the rulings in order. That was one of the things that could occur in the future. And additionally, part of our role is to make very specific findings, and that's one of the things that came out of this seminar is for testimony, and in fact, Dan even said that as part of the read-on, is that your testimony should be directed to the issues that are before the commission. And so, since we are making recommendations to council, and Jacob had even mentioned this, if you're going to make a decision, try to have your reasons outlined. And so a lot of these rulings that we are making are based on code findings that we need to make or not make. And if we can focus the testimony on the code findings that we need to make or not make, and then we make findings, I think it will generally help the council. Because we will have heard testimony, we've made findings and made recommendations. And it also will streamline the hearings. Because there was a lot of stuff that banter, which was really not pertinent to our decision, just really didn't have anything to do with the facts that we needed to decide or the rulings. So I'm only bringing that up because we're gonna have a lot of hearings in the future. And I felt this seminar was really good. I learned a lot, and I'm thinking that we're gonna get better and better as time goes by. Those are just things that I want to bring up for discussion or whatever.
What about keeping it to the items in the hearing? Is the public is not getting better and better because they've been to so many hearings, maybe the only one they've ever been to, so they don't know how to do it right. I mean, state rule, I get comments on permit applications all the time, and you don't know how to comment properly. They go off on all kinds of stuff that has nothing to do with my decision making. I'm used to that, but they're useless too. So I think it's important that they know what's valuable for us. Maybe we need to explain that before they come up. They are open to, like you said, Jacob, this is a public thing. You have the free speech. You can talk about what you want, but you only listen to the stuff that's pertinent. So I don't know how you say that
Well, the script.
and how you shut them down.
Yeah, the script that you read every hearing says it.
I know.
It just, all testimony should be applicable to the substantive criteria listed in that, it says it.
Yeah.
It's just that that's not like received.
And I think
Point of order, if they get way off base, they might be calling for point of order.
I found out what's interesting is that it when, even though a lot of the testimony is not applicable or directly applicable, it is like sometimes the first opportunity or only opportunity where someone has come to a public body to express themselves. And I've been very kind of like sympathetic in that way, is that they kind of see the commission maybe as a open forum that they can express themselves in a public way that they wouldn't otherwise feel comfortable. But I also do feel the frustration because the same thing happened at the last council meeting when the hearing came, many of the same people came back and gave the same testimony, most of which I would say was not relevant to what we had to consider, so.
Limited to 5 minutes though.
Yeah, that we did, yes.
Yeah.
So we did have it cut, but still, even in that context, a lot of the testimony was not.
The challenge is one, people's sense. Every person out here is a customer. They're a citizen, they're a customer, right? So we want to treat customers right. Oh, you can't just talk. Then they leave, well, the city doesn't listen to me at all. The other challenge is, when we're reading those introductory statements, these are the standards which apply. But then there's also if there's other things that you think apply, there could be something which someone thinks is legally tangible. You wouldn't want to necessarily suppress that. So it's really tough. I think this is going to be a phenomenon planning commissions deal with for as long as humankind exists, because it's human nature, and that's why.
It feels like the planning commission has a little bit more sideboards on what we can decide against. We've got the ordinances, or whatever you want to call them, the city code, where the council is more political. They can listen to things that are more general and decide in a different way than we can. And maybe I'm wrong on that. You have to hold to what the actual city ordinances are in your
I think-
decision?
I mean, I think so. When I made my decisions, I believe I'm bound to the law, the ordinances, the code.
I'm good to hear that.
The difference though is the council is a legislative body and has a higher degree of interpretive power. More than the planning commission, so that the council is able to interpret their own code. That's the way attorneys have explained it to me, and so there is a little bit of a difference. There.
Right, but it's still, we're supposed to be applying the code.
Yeah, I mean,
And we may interpret it differently, but I mean, we're supposed to be basing it on what we believe is legal.
One of
Not
the things,
on what's gonna please people or.
one of the things on that seminar that we attended, and I think I interpreted it wrong, so clarification would be helpful to me. It seemed like they said that what they present, the applicant presents to the planning commission, they must present the same to the city council, but I understand that, I mean, you're gonna refine your presentation, probably what we didn't like, they can, or wasn't enough information, they probably would refine in the city council meeting. Are they hearing the same, the city council hearing the same presentation from the applicant that we?
no.
which
And-
could-
In the famous examples where the planning commission has been pissed off at the council, Emerald Meadows, no, because they appealed it and they regrouped with their attorney, they completely restructured their argument. We've seen that.
And it will, similar happened with the Schlumper.
I don't remember that in the presentation
That's what I
either,
think,
so I,
I'm interpreting it wrong.
I know in my work, I have to follow the OARs that we have. I don't have much flexibility. Well, my director or my deputy director, they can make a decision that's different than my interpretation. That's, they have that ability to write. I don't.
similar.
I think of it the same for the council, but I may be wrong in that.
I just wish we had a lie detector.
As a trial lawyer, I can tell you one doesn't exist. I think the more defined, it depends on the procedural context and the legal context of our rulings. But if we have a factual basis to make rulings, and we then make rulings and make recommendations to council, depending on the procedural context, I'm not sure if council, I mean, this is a whole give and take between the planning commission and the council. But I'm not sure that, let's say the planning commission, we hold a hearing, we make findings that are directly pertinent, we make a ruling. Then we go to council. And then council reverses our ruling without making any findings, without making any discussion. An aggrieved party potentially could go to a higher body and say, there was no basis for the council to rule the planning commission. Planning commission made findings after a hearing, and council did not have a basis to do it. It just did it. And that would be, I'm not sure if that could ever happen. I'm just saying that when we make findings and we give them to council, that's the council's message that, look, we held a hearing for hours. We've made these findings. Not sure if they're binding, but I'm not sure if they can be just completely ignored. I don't know.
Shouldn't be ignored.
Right,
I think they have to be taken into consideration. Again, the interpretation would be different, but I can't know. It would be wrong just to ignore.
and I think that's what,
I get the feeling it is.
I don't have that feeling. I think that we're moving much more to
Meadows.
well, I wasn't there
We're
then.
here for it.
And I'm gonna just say that, all I can talk about, I mean, I wasn't here for
I know,
Emerald
I know.
Meadows. But when Jacob brings up your findings specific, like, for example, for Comstock, we found it was spot zone. We made that finding. That's why we ruled against what we did. There was a ruling. I'm sure that was probably helpful to council to say, wow, planning commission found spot zoning. Why did they do that? And then it makes them think, is this spot zoning or not? And so I'm just trying to bring it up as a way we can make decisions that fit within the framework of the law. Because honestly, I don't think the council, we're spending a lot of time doing a lot of hearing work, listening work, ruling work that helps the council. The council has way more on their plate than we do. And it helps the council streamline their decision-making. So, and that's one of the things that came out of this little seminar. So just, it will just continue to move in that direction. That's just it. I think it will help.
We can always give a rebuttal the next meeting of ours back to city council about Emerald Mounds or whatever.
A rebuttal?
Like a debrief?
A debrief, yeah. So we did this and this and you're not really following that.
Yeah.
I mean, they were talking about, well, we want to do this because we want it to be affordable. That's a nice sales pitch, but that doesn't work.
We have a liaison who can relay.
Well, they made it affordable and then they put our 7 houses, came back for variances. So they put our 7 houses on it.
Well, they went back several times, yeah.
Yeah, yeah.
Anyway,
It's not affordable.
well,
One of the things that came out of this seminar, I keep bringing it up, I thought was very helpful, was that they thought that the planning commission and council should be meeting. And we should be able to sit down, meet and discuss
Why?
like once, why?
The why we made the decision.
Well, I just think communication and how
Right,
how they look to us and what they look to us to do. You know, there are gonna be proactive items that are gonna come up. I mean, I submitted one to Jacob. It's gonna be and Christina, it's gonna be potentially open for discussion next meeting. And as and not only proactive items, and I'm hoping that by taking on some of the proactive stuff, we're gonna take some of the burden off of the council trying to make difficult decisions or enable them to make better decisions. And also, we're gonna be reviewing things, so I guess I'm saying that I think we should meet with the council probably at least once a quarter, just to open up the lines of communication, they can talk about, council can talk about their needs, how we can help them, communicate our decisions to them. They're busy people too, you know, Patrick's got his job and everybody's got their job.
I do have the summer, I'm a teacher, the summer's off, but yeah, but come September. it will be-
So what was the council's decision on the planning and development portion? That was your decision. Or
We upheld your decision.
Oh, yeah, I didn't know.
Yeah, we upheld, yeah, so we did uphold it, yes.
Yeah, the ordinance is still pending.
Yes,
But the second reading is scheduled for this coming Wednesday.
and it was, yeah, unanimous. Of the 4 of us, Councilor Chilton wasn't there, but that was unanimous.
Did they appealed
Um,
or the second,
the subdivision has been appealed. And that goes to the council next Wednesday.
okay, that's.
The plan development overlay, once the second reading occurs, that's when we send out the appeal rights notice.
The applicant has hired an attorney.
Okay. Okay. And
Good.
and then as far as the street variance, that hearing has been continued. The first street, vacation, sorry, yeah, the vacation, that's been continued, that hearing is still open and will continue at the first September
7th.
meeting.
5:30.
Well, I think that if there is go ahead, I didn't mean to.
No, I just said interesting.
If there is well, first of all, we don't have to make a decision today, but I do think we should be moving toward meeting with council in those lines of communication and trying to just communicate, which was a recommendation from these very prominent planners from across the state and their attorneys.
And I can report that, Wednesday. Right? Wednesday about the request, if you want, does quarterly, I mean, go ahead and set quarterly meetings sound? I mean, you want to put it on the calendar instead of going as you go basis, do we want to look at it for a year and set dates?
Yeah,
Yeah.
no, I think.
Okay.
Wonder if Kathy would want to start that effective.
Well, right, I'm not saying we would start, maybe we start in January when we do the whole public meeting calendar and announcements and things like that.
We need one in March and June,
It might be good to
September,
get one in
and
before
December.
the end of the year.
Yeah, no, same time the checks come out, you need to, well, that's quarterly, is what I'm thinking. It's still on the refrigerator.
We'll see, I mean, Jessica just had her baby. See if we can do it. Keep our fingers crossed, but there's also an election coming, so.
Is there, yeah, and still time to file until the 15th. We have, anybody who's interested in filing for something has until the 15th.
All right.
Some people who file.
And then if one more thing, if I might, on this one. If there is an appeal or whatever legal action, because this is out of our hands now, the comp stuff, right? Would be interesting to just kind of get a report back on what are the legal arguments being raised. Because I'm sure the lawyer's gonna pick it over and try and find where maybe we procedurally, I don't know, I'm sure they're gonna look for all the i's being dotted, t's being crossed, and they're gonna try and find ways to
All the shells and
obtain the-
mays,
what's that?
all the shells and mays.
Yeah, all the shalls and mays are done, so it would be interesting just to see what the lawyers bring up as their contentions on why they feel that their clients are entitled to relief. Just as informational, hopefully to help us do a better job, because I mean, our work is reviewed, so is the city's council, there's a higher authority that can review our work. And getting it right is very important.
And we learn from each case. Usually we'll install that knowledge into whatever it is.
Jacob and I went to the Luba appeal for the mining site design site.
You were there too?
Yeah, and I went to
That's
that,
all.
and also to the appeals court.
It helps when you work in Salem.
That was,
Oh, that's right,
This is
it's
my
down the
building.
street.
How many-
Same
It
building.
was removal case.
Just walk down the
You were
hallway.
the,
downstairs, it was.
Yes.
And then I went to the appeals court, that was pretty interesting, the view of us, they're beautiful.
Wow.
Yes, yeah, it was interesting to watch the other attorney work, try to work the judges that weren't impressed by it.
Especially when they say it's just legal mumbo jumbo and kick the chair. I'll never forget that. This is your argument in front of the Court of Appeals? It's legal mumbo jumbo and you kick the chair?
Brilliant.
He interrupted the judge. Yeah.
Wow.
Yeah, that was classic.
Exactly.
Okay, planning commission meets starting tonight.
Yeah, so this is me as well. I had heard through the grapevine that Christina had maybe talked to you guys individually about this. Now that we have hybrid meetings, anyone can attend virtually. And I feel like the justification that people are commuting for 2 hours to get to a meeting isn't as strong as it maybe used to be. And so the idea that we have our meetings in the afternoon is people work and we're dealing with land use and property rights and we need to be available for people who work all day. But I think 6 o'clock is still very reasonable to start a meeting and still get there after work. And so I just wanted to have the conversation. This is, well, I want to hear what everyone has to say first, but also this wouldn't happen immediately. This gets adopted at our public meetings calendar that Kathy puts before council in January of every year. So it would happen 2023 if there were a change. But yeah, I just wanted to see what everyone thought about moving the start time to be a little bit earlier.
I'm okay with that now. I remember when I was interviewing for this commission meeting on here, my friend Vern Fisher was counselors and he had the computer store. And so they asked me if I could make it from Salem in time. 7 o'clock meeting. I said, well, I beat Vern. He works across the street. But
Vern was always the last one here.
yeah,
We could sit here and watch him coming across the park.
but I don't work at Salem now, so we're good. I'm concerned.
I would be in favor of starting earlier.
Essentially, city council does, because with that last meeting, I was thinking 7 o'clock and I was gonna be down here, and then I reread what you wrote and I got at like 2 minutes after 6.
Oh, public hearings are always before the regular.
Well,
Yeah.
but I wasn't thinking that was, I was thinking they start like we do at 7.
Right.
And so that's why I zoomed in, because all of a sudden it had started and I was at home.
I see. Oh, yeah, you were in the meet, that's right, you were in the Zoom.
No, I was there.
I remember that, you were listening.
So have you heard from the public that 7 o'clock is too late, 6 o'clock is okay? Or just assuming it's okay?
I haven't heard from anybody. I just think that we offer different ways to connect with the meeting.
I just don't know, generally, public meetings that they're meeting the public for working people, where do they start? Do they 6 o'clock, 7 o'clock, those ranges, a normal range, or we just think in a small town, St. Helens must be okay at 6 o'clock? I'm making fun of you, just.
No, it's a good question to
How is it
compare.
for Russ?
We'd be done by now.
It won't matter.
He's only got one more month,
Be-
right?
I'll be there in person next month.
Hey,
And 6 would work for you?
Yeah.
Okay, so that's
Well,
every,
and we have time if you want me to kind of research and do some case studies about, communities in Oregon when they start,
I like that, but I
just
don't
to
wanna
have, yeah.
cut people out that know that our time is at 7 o'clock and then always make the meeting. That do work at 7. or whatever.
well, we can always have meetings starting in January, we'll be at 6 or whatever, announced. You
So
know.
something else, Dan, when we have a hearing and we're scheduling it, we always try to think about what's gonna be the most convenient for that applicant. So sometimes if we have a variance, ideally, we would have put him at 7 o'clock and then the other, the longer one.
Right.
So we do have some flexibility as staff to be able to coordinate with the applicant when their hearing is before we schedule it. So if someone was like, oh, I can't make a 6 o'clock hearing, but I can make a 7 o'clock hearing,
We're talking for a while.
We
We're here
can-
for a while, yeah.
we can, shift things around before they're scheduled. Just not always. Sometimes the hearing gets scheduled and they're, set, but yeah, I can come back to the next meeting and just provide a
We'll
little
spend a
more.
lot of time on
Yeah, everybody works.
polling every city in Oregon.
St. Helens, that's pretty weird.
I'm for 6.
6 o'clock. Russ?
And I think that to underscore your point, Jenny, and that is, if you can't make it, you can come by Zoom.
Mhm.
And I've actually appeared, I wasn't here, but Russ is appearing here from Ireland. So I mean, he made the meeting.
You're on the road, it might be tougher, you can call in, I suppose, if you always have to sell. But
Well, pull over and get on your Zoom and, do your thing.
2 hours in the rest of
The applicants usually know about a month in advance too. So hopefully
Plan your day around it, yeah,
make accommodations, yeah.
I would.
There's always pros and cons. One thing though is when we're here late, the rest of the week is screwed up. The rest of the week is inefficient because then you're tired,
Yeah.
you're trying to catch up and you can't. And so if you have a Tuesday with a late night, Wednesday, Thursday, Friday is effed.
It's true. My Friday, I'm a little bit better, but yeah, we all experience.
I leave at 5:30 in the morning the next day.
Oh,
Look at
Yeah.
film,
Yeah, that's brutal.
that was horrible.
And
They also have an hour drive.
Well, that's what I'm thinking. They get
Isn't
all the
there-
time to turn around.
isn't there OT too, that city must pay? for-
So
Comp
for-
time.
For union employees,
comp time?
Christina and I get time and a half, anything over 8, but it's not
Right.
pay, it's time off.
It's comp time.
Policy.
But it does save money potentially over the long run if you just add it all up.
Oh, no, having more efficient meetings is better for
Yes.
everybody,
Yeah.
including the city.
I'm
Yeah,
not trying to take money, it is
yeah, no, it's
Savings.
substantial. Yeah. Well, I'm kind of getting a head nod for 6, Dan, do you still
Yes,
want to
yes.
work? Okay, all right. Cool, well, I will,
I'm good with 6. I just was trying to think of the public, just making sure that we're not cutting them out of the equation.
yeah,
They can't come in, because now they can never get here,
right.
that would be bad.
Like you said, they get the agenda, so they could call in and ask for maybe a later, they could work with you.
Yep.
An applicant for sure.
Yeah.
Yeah, and Dan, they can always submit written testimony. which is
There's
what we
many
did.
means of submitting.
And
Right.
we can read it
Let's just go
aloud.
with it and see what happens.
Well,
Yeah.
it's because the council regular session starts at 7, it's common to have public meetings 5:30, 6:30.
We already know about hearings.
And in all these years, I don't recall anybody at a council meeting saying, this is too early.
Yeah,
I just don't recall it.
It's true.
we're good. That's what I was asking.
So this would be a change. I asked Kathy if council had to approve a meeting time switch, as you said, it's up to you guys as the planning commission body to pick your start time. So it just gets set at the beginning of the year,
Like
so.
Parks Committee, it meets in the middle of the day or something.
4
Yeah.
o'clock, yeah. So, our counselor will just bring this to council and let everybody know. All right, 2023.
Remember.
Yay.
Does that mean the next meeting? This mean the next one will start?
Until January.
Make sure remind us, Christina.
No one's gonna challenge that.
Sure remind us, Christina, when you.
She's good.
Yeah.
It
for
won't,
next
it
year.
won't take place until January though. Not next meeting, guys.
Yeah, right.
You can come at 6, but no one will be long.
Lights will be off.
Bring a picnic, we can sit in the park.
All right. Here's the next item. What is measured? 109.
So do you all wanna go on a trip with me?
So silly.
If you do, we need to wait till January, after January 2023, because that's when the Oregon Health Authority will start issuing licenses for things like service centers. And in the context of Measure 109, the bill regarding psilocybin, that is where people can obtain their psilocybin product and use the psilocybin product. There's also provisions for manufacturing and stuff. So we are talking about Measure 109, about psilocybin. This was adopted or approved by the state in 2020, and it allowed for 2 years for the health authority to develop licensing measures. And they are well on their way of doing that. We anticipate licenses beginning in January 2023. And there's 2 license types of that are noteworthy for us. Manufacturing. Now, manufacturing includes growing, growing the mushrooms, but also processing. So it can be extraction, chemical synthesis, stuff like that. Manufacturing and a service center can be in the same location, and the state law specifically says no outdoor manufacturing. So that's the manufacturing thing. Probably not a big deal. I think it's gonna be just like manufacturing is allowed anywhere. Does it have offsite impacts or not, like odor? Service center is the more interesting one. That's why I kind of introduced it in kind of a funny manner. So that is where people can obtain
the psilocybin product, it's where they can use it. And that is the type of thing that could get neighbors or communities excited. Now, St. Helens passed this measure. Thank you for Rachel Berry for thinking about this pretty evenly as far as passing it. It wasn't, a huge discrepancy either way. And that may be germane to where we're at now. So one thing that this law allows is for cities to either outright ban manufacturing or service centers or enact a 2-year ban. The council discussed this. They passed a resolution for a referendum. You can't just do it. It has to go to the voters. So they passed this resolution. So in the general election, this community will vote as to whether or not to delay the allowance of the psilocybin land uses for 2 years or not. As staff, we did favor it. We would like more time for the League of Oregon Cities to develop some model code and also to kind of see how they operate. Manufacturing is manufacturing, industrial zones. I think that's easy. The service centers, they're kind of weird because, my first thought is if we didn't have rules, I guess we would allow them where there are clinics. But the facilitator, this is the person who facilitates the psilocybin it's consultation and during and after, they need to be licensed by the Oregon Health Authority, but they don't need to be a doctor. They don't even need more than a high school degree. And so how that all plays out is yet to be seen. So I'd like more time just to see how things happen, and that 2 years would give it to us. But we're at the mercy of the vote. Now, the challenge is, that's going to be in November. And in order to enact development code law, you have to write it, go through all the reports. This would probably be what we call a Measure 56 notice, where if you're enacting new restrictions, zoning restrictions on land, you're supposed to send a particular notice out. The last time we did that was pretty recent with our duplex rules. We sent a whole bunch out, and probably a lot of you got those. And of course, the general election, by the time that is in January 1st, there's not enough time to really do that stuff. Now we kind of have a model for it in the agenda folder. I put a map in there. So way back in 2015, we were dealing with marijuana retail.
Sorry, I need to share screen so Russ can see it. Just a second.
Yes, please.
I'm not forgetting about you, Russ.
And so there was a series of different maps because we were trying to figure out, okay, for these marijuana retailers, what kind of separation do we want? There was already a rule that they had to be 1,000 feet from schools, and these service centers, these psilocybin service centers, there's already a provision that they can't be in residential areas and exclusive residential areas, and they need to be 1,000 feet from schools, although there are some exceptions, like 500 feet or so. So back in 2015, we were dealing with marijuana. Medical marijuana was already legal, but the retailers were not. And so we were exploring the 1,000 feet from schools. And in this map, we were considering, okay, well, what would it look like if we had 1,000 feet between these centers? Now, if we did impose time, place, and manner rules over service centers, we can't require more than 1,000 feet between the establishments. In the case of the marijuana retailers, we established a 2,000 foot rule. And it worked good as far as having one of those in each commercial district of the city, the highway, Holton, and Riverfront district. So it's nice when it actually works. So ideally, the voters will pass this, so we have some time. If not, we may need to scramble or just cross our fingers. Because it's at just the medical level, not the retail level, I'm assuming these aren't just gonna start popping up everywhere. They still have to be licensed by the state. If it was retail, you know, we probably wanna be on that. So I wanted you to be aware of this at the very least.
Do you think it's likely that the service centers will be in the marijuana shops?
That's what I'm
I mean, the
thinking.
bar is so low, the qualification of the servicer, that you just wonder if the marijuana shops will then.
Like
co-locate. Yeah, like be the applicants, likely applicants.
Yeah, that's a good question.
Yeah.
Cause I'm not that familiar with the, other than, you know, not being in residential areas, a distance from school, the exact licensing requirements from the Oregon Health Authority that, I mean, they're in the process now. It would seem inappropriate to have something that's more medical be combined with something that's retail. It seems like a conflict, but you know, I don't know.
If it's not being prescribed by a physician, it is not medical, period. Somebody with a high school education can hand it out, it's a joke. Make sure we understand what it is.
Are you tripping, man?
I am tripping. Well, kind of,
I can't help it, it's a perfect joke.
that's all right, I
It's
mean,
gonna be dope. Is that what
it's
you're
good, my
saying?
statement's gonna be dope.
Okay,
So,
just
so
wanted to be.
one of the things that's gonna be coming up for our consideration is how this homeless defense, of this HB 3115, and our study of the homeless problem and the reasons for homelessness. One of them is drug addiction. And, you know, people want to do drugs, they'd rather buy drugs than pay their rent. They'd rather buy drugs than eat. They will steal for drugs. And there's a very large section, and if we decide to do this HB 3115 thing, we're gonna find out what percentage of the homeless population are actually drug addicts. And I think the state of Oregon, they passed the measure and I guess the people voted for it, but it's a very slippery slope. I don't think more drugs out there is helpful to anybody. That's my personal opinion. And I know the council put this, this on the ballot, but I'm wondering if we should study it and we should come out with a recommendation to the public. I'm also completely against permitting something that's violating the federal law. And we're not talking about pot, we're talking about psychogenic drugs.
That's right.
And that do cause trips, that do cause alteration of consciousness, that do cause hallucinations, that people can get hooked on. And it's a very dangerous thing, and our federal law is prohibiting. And honestly, the US attorney could go in and bust people, they could arrest people, put people in prison, seize property. And I don't think we as in the same, I can tell you what I've heard from our citizens too, is people come in here and they say, why is it that the homeless don't have to obey the law? Why is it that they get to just stand wherever they want? Why can they lay in the street? Why can they do all this stuff that I can't do? Everybody should obey the law. And we're gonna pass a law that's gonna allow people to come into our city and violate the federal law on something like this. So I think there's a lot of problems with it. And I know the council put out an idea of a vote. And maybe the opinion is let people to decide, but I think as a planning commission, we probably should help the people, we should help guide the people, since it's gonna fall in our lap to regulate it anyway, potentially.
Yeah, it could be, ideally, it'll be in 2024 or 25.
It was two choices, totally outlaw or 2 year.
Well, that's what the council has,
Right, they chose 2 year,
2-year delay.
not the, so they made that option.
Yes.
Right, but also both of them had to be referred to the voters, so the 2-year and the total.
Oh, okay.
If we had recommended a total ban, that still also would have gone to the voters. So
Yeah, referendum.
essentially, it's the voters.
Yeah, so this isn't going to voters. The state says, okay, here's what you gotta deal with. But you can use a referendum to not deal with it. And so that's what's going to the voters. For us, what happens if they say, well, we wanna have these for whatever reason, supporting mental health, et cetera. Then that's where our time, place, and manner rules, at least within the confines of this measure, the measure does limit some of the things you can do. For example, you can't impose more than 1,000-foot distance between the service centers, which is different than our 2,000 feet between the marijuana centers. But there are some things.
I just think it's the wrong message to send the kids to. You got parents trying to tell kids between right and wrong, between good and bad. You know, if you follow the rules, these things are gonna be good for you. If you don't follow the rules, things are gonna be bad for you. And then they walk by these places, oh, buy your magic mushrooms, and you know, the mushrooms are on there as well as the weed things that really. And I think it's very, very, number one, I think it's a giant mistake. Can't erase that, but I certainly think we should do what we can in our power to make it,
More
at least
difficult.
educate. We don't need it in this town, period. That's my opinion.
Totally agree.
Yeah,
So, you know, why don't we have, I mean, we're jumping ahead, but we should do something. So let's just say this. Today, or yesterday was the last day to submit something in advance to staff, because it's 20 business days ahead. So in order to, I mean, I don't think we should just come with our personal opinions. I think that we should look at this, allow people to come forward and express their opinions. If we're gonna make a recommendation, at least a public recommendation, it should be something that's done in a reasoned fashion. So.
Well, I don't know, is it even possible? I'm just, this is just speculation, if there's gonna be a voters pamphlet. Is this something where the planning commission submits a state, are you even suggesting something like that? I don't know, so anyway, I don't know, this is kind of uncharted territory.
Yeah.
About just what the role of the commission is for this particular type of issue. Anyway, I don't know, it opens up some interesting
We
possibilities.
do the timing where we could take it up in October for a recommendation for voter recommendation for November or not. Or we could potentially shorten our time frame if we agreed to do it, I suppose, and staff was okay with it. It's, you know, I think we need to say it was less time, but staff always has the option, I think, of saying this is gonna overwhelm us.
When are OLCC rules finalized for permitting them?
Yeah.
Or licensing them? Are they already out?
No.
They're in process.
Yeah, no, that's one of the reasons we suggested the 2-year moratorium.
You don't know what it takes.
We don't
to
know, we
license it, so-
don't have anything from the state to guide us, and nothing from the state. And then nothing then that the League of Oregon Cities can provide us, so that's why we were thinking for at least a 2-year moratorium.
So is it going, because I know that I was at the council meeting where there was the vote to put it on the ballot, so what exactly is going on the ballot on in November?
What exactly, well, I don't know if you do get Kathy, it's a city resolution number 1961, the text is in the city website under resolutions.
Simple.
But it's basically a 2-year moratorium on manufacturing and service centers.
Is it in their regular session?
We,
It's an adopted resolution, it should be.
Well, Kathy just sent out an email too, so yeah, it was, we adopted it at the meeting on the 3rd.
Resolution 1961.
Okay, I'll pull it up here.
But I also think I think the some of the discussion or thinking and my own personal thinking is that I think that seems to be again, whatever the voters will decide, but a sense that voters likely would that residents would likely be in favor of having these facilities available. And
Yeah, go ahead, sorry.
that in the end, it's not going to be a city council decision. I think anyway, the voters have the say on it. So we just have the option of doing nothing, right?
Well, I think most people don't have experience with psilocybin. They don't know what it really does. And I think a lot of people think it's benign when it actually is not.
Oh, I think you're gonna look at the word and not know what it means and say, nah.
Yeah, why
Okay,
not? It's just a
what they-
mushroom. I mean, I
Well, they're
think,
not even gonna know it's a mushroom.
It could be life changing though for somebody that really needs it, if it's prescribed by a doctor as alternative medicine, it could save
So put it
somebody's
in
life.
pharmacy,
I mean, there is a
Prescription.
there
that's
is
what I'm saying.
the health, possible health
Years old is having
benefit for some.
a shop or wood shop.
We cut it off for some because of what some might. So
Right.
could we go down a little more?
Yeah.
I've read it so far.
I'm
Prohibiting psilocybin service center manufacturers on the adopts. Yeah, so the measure is going to be, shall it be prohibited? Just.
Oh, sorry, I was gonna go to the exhibit. I think that's what you're looking for. Want to keep reading?
Explanatory statement for measure.
Nowhere says what it is as a product.
The majority eligible vote yes on the measure. Psilocybin services centers and manufacturer were prohibited within the corporate limits for 2 years. So a yes is a 2 years.
the
How many people that don't know that word are gonna look it up? I'm serious. You know? Oh, okay,
Well, they're interested already, they'll know,
they know,
they'll hear.
I understand
they'll learn
that, but when your general public is voting on it,
Well, I mean, tell you what our procedures say is that that's why whoever suggests something needs to make sure that it's within our powers, and then we review it and we discuss it, and we make a decision. So I still think that there's time between now and November to, I mean, we have 2 opportunities to decide what we want to do. October may be late to actually do some kind of decent study. September may be barely enough time to where, let's say if we decide we want to study it in September to make a recommendation in October. That will only give us a month to study it, to either make it so the September date would simply be a discussion of whether we wanted to look at it or not. We may decide, forget it, and
well, the date, if you're looking at September 8th, as far as their recommendation went.
I think our meeting's the 13th, so it'd be.
Yeah, after.
So if we bend the rules on submission, if people feel passionate about it, any planning commissioner that wants to submit by, let's say, Friday, the proposal that the planning commission should consider whether to make a recommend, to study. To study for a month.
Study what?
To study, to study the communication to the public of what psilocybin is. That how it violates potentially the federal law, the negative effects of it, how it affects children. Why or why not it's a good or bad idea, so that we can, make a resolution, decide what we want to do with it.
But I think, are you clear on what you're doing with, wanting to do with the resolution? Because, okay, so a yes vote means that we are having the moratorium for 2 years.
Right.
But then at the end of that 2 years, we're moving ahead. A no vote means that we have to be, as of January 1, begin. So I think is your argument going to be, even though you are, may be opposed just to having this in our community, period. The question is, would you be recommending the moratorium, the 2-year moratorium, and giving your reasons for that? I think the bigger issue, whether or not you think this is a good or beneficial thing, is not directly pertinent to measure.
This is one
I
of
think
those
that-
where the public needs to know that a yes vote.
It's how it's
For
drafted.
2 years.
It says shall St.
Yeah,
Helens
that's right.
prohibit psilocybin related businesses for 2 years.
But you have to vote yes to get that.
Right.
Yes.
Pretty clear question.
I understand that, but people look at things like, yes, I want the tax, no, I don't want the tax. If
Let's,
it's written,
let's just say this, I've expressed some strong personal opinions, but I could be persuaded the other way. And the point of it is that the commission would decide if they wanted to take it up, and then the commission would decide what communication, if any, to be made to the public. I have one vote and one personal opinion this. After we study it, who knows, maybe it'll seem like the most wonderful thing ever, that we should all encourage everybody to say, no, let's go forward, and have these things everywhere.
only we're having samples while
I
we're.
don't see, what the recommendation.
Rehearing.
I don't see what a recommendation would accomplish not really
Residents aren't gonna know what your recommendation was.
Because I think
recommending psilocybin use or not recommending it.
Yeah.
It's just delaying the sale of it here in this city is all this vote is about.
Yeah.
so
One second though.
That ship is passed, I think, whether it's gonna be good for Oregon or not.
because after December 31st, 2024, right, that means January 1, 2025, it's going to be happening.
Yeah.
They're going to be. So what we're asking for in this is, do we want to just January 1, 2023 allow this, not knowing what the playing field is with the state regulations and things? Or are we basically, or do we want the 2 years to find out, learn more about it, and how we can safely do or responsibly do this in our community? I think that the question isn't, are we ever going to have this in St. Helens? That it's going to happen. Is it going to happen January 1, 2023, or is it going to happen January 1, 2025?
Well, I disagree with you there, because it hasn't happened yet, and you're talking to somebody who is saying it shouldn't go forward. And so I don't know why the council referended a 2-year with an automatic clip.
Because those were the options presented to us. We were presented either a total ban to do not, we have 3 options: do nothing, and it starts January 1, 2023. Ask for a 2-year, in which case, if it's approved, it's the 2025, and the other is a total ban. And my sense, and I do believe other councils, reasons we voted for the 2 rather than the total, is that the community would probably support wanting this available in our community, but that we need to do it in a planned sort of way. so that I've kind of figured if we went for the total ban, it would certainly go down. And we'd be stuck with January 1, 2023.
Essentially,
Yeah.
you've got the two-year moratorium. You would be able to still come back with a total ban within that 2 years.
Yeah, that's.
I don't know.
Will we be able to do that again? I don't know. Well, that I don't know.
Yeah, that's the question.
That I don't
I
know.
think that you may be able to keep the.
Keep going?
two-year Thing.
I don't, okay, well, that I know. So I'll, yeah, correct it there. I don't know. That's a good thing to find out.
But I was gonna say, I don't think that this body is the kind of body that should be doing recommendations to the voting public on how to vote. I don't think that's an appropriate role for us.
Well,
That's none of our business.
that may be true, and that may be correct. And that's why we have a procedure to review whether we take on something, and the person who's advocating it has to bring forward the powers, and then we make a decision. I'm not sure if this is something we want to do or not. The only question I'm bringing up is, do we want to try and consider whether we do something next meeting? Because if we don't do something by the next meeting, we aren't gonna have time to study it, and make any recommendations.
Can we really do that, though? I know as state workers and city workers, you're not supposed to talk about what, voting
Right. That's what I'm saying.
candidates.
But as a body, we could be in the pamphlet, we could put that in the voter.
I don't know. That's what I'm wondering.
Got a deadline. You could probably say, you could probably at least provide educational information, but I think that is a point. Can you speak in favor or against as a body?
Yeah.
That's maybe a
Well, I sure
different.
can't do it as a state employee, that's for sure.
Well, the planning commission actually has the power under section 18 and the duty about the morals. And, people say about the morals, it's like, that's what parents come in and say, is why are we allowing lawlessness? And are we contributing to this culture of lawlessness? There are a lot of things to consider about this thing. Now, I'm not saying that's something that we are gonna rule on, or we're gonna give, you maybe decide not to do this at all. I'm just bringing it up as we can consider whether to do something, and whoever or not, and whoever advocates for it has to bring forward the correct powers. I mean, let's just say hypothetically, under our new rules, let's just say I wanted to bring this forward. And I bring it forward, and we could show up at the next meeting and people could shoot it full of holes and say, forget it. Then it goes away. It's off our agenda, it's gone. We don't deal with it. The point is as a planning commission, do we want to say something? We want to try and educate, but there's no way to do that unless the next meeting that could be held would be September.
The only education that we can do related to this thing that they're voting on is what the voters pamphlet is not spelling out clearly. The yes vote means this and no vote means that.
That's
the
what
only
I
thing
would say.
That's the only thing we can educate.
Yeah.
We can't, it's not educating about the drug. There's nothing to do with that.
You know what, I'm gonna leave it alone right now because I think what we're
I
gonna do.
hear what you're saying, but I don't think there's anything that we can help the voter with education to make their decision that has to do with the evils of the drug or whatever. That's not the question.
Well, procedurally, let's just say this. I'm channeling Sheila here. Okay, and Sheila says baby steps. And well, you know what, that's good advice.
Yeah.
And there's already a proposal that I wrote up that has been submitted and has something that, to me, I'm hoping that we'll take on. And I don't want to necessarily try and cram in this mushroom thing in there and try and bend it. I want us to exercise our taking up proactive items and working them through. And maybe just, this kind of discussion of whether we should is something that actually occurs in the meeting after a submission. But I don't wanna try and force this and, or, continue with it. I think there's enough reticence where I'm dropping it as a commissioner at this time. So, but thank you, Dan. Dan, I mean,
No. And you said what I was trying to
Good
say.
discussion.
Can I add one more thing? Jacob, are you working on selling land that we are vacating? I'm going to the lock thing. We don't have anything that on vacated land that the city owns. Where you, like,
Whether we should be
if-
paid, whether the city should be paid for land that gets vacated, is that it?
That is a classic question
Oh, yeah.
that has come up many times. Ideally, so this is why one of the many things we've talked about doing is having our own right-of-way vacation rules that supplements the state's. That's where things like abutting can be clarified, whether or not a fee should be imposed. The statute is silent on the fee. I know places like ODOT do that. And I just know if we start doing it, we would wanna be consistent.
Taxes are getting increased though, aren't they? Property taxes.
Taxes, yeah, cause the area would increase, so the assessment would change, yeah.
So I have a brother-in-law who's a specialist in this. He has some land in Seattle, in green space, bunch of lots. There was a road platted at the bottom of this ravine. It hadn't been built in 150 years. And it was 1870 law, whatever he found, that if it hadn't been developed, it went to the adjacent property owner. And the city wanted to make this green space, so they had to, they fought him anyway. They ended up paying him for the land, for a trail and this green space, it would be a city green space. So it's the opposite direction, but it's same kind of thing. It was the landowner owned it, basically. I mean, I think people could find that law and find that that was never developed, that street or whatever, that it isn't owned by the city anymore.
That was Washington.
Yeah, it was Washington.
Yeah.
But I don't know if that's necessarily a Washington only law, but anyway. I won't say it honest. He's
You
really
mean
good
you
at
don't
it
have a
too.
lot to do, could you look into doing something with that?
Well, that's why it would be up to the council. This is something we've tackled many times. It's a question we've tackled many times over the years, and I have my notes for when it ever comes up.
Oh, I know we've talked about it,
So
but I just,
we have to see what happens on that too.
no, I understand, it can't be retroactive, but I just don't want it left alone for the next time. And when you don't have anything to do, you can work on it.
actually, you could submit it as a proactive item that, I can help you find the code section and you could say that, I think it has to do with disposal of land and changes of use and zoning, that would fall under our powers and that we would then take up an item that would be a recommendation for council for legislation to zone different areas of land that the property is vacated. It's gonna cost the person who gets the property a certain amount of money. And so then we could take it up, we decide we wanna take it up, we can study it, we can make a recommendation. So, if it is something you want to do, there is a means by you where you could do it. Not for this particular thing that's going on now,
No,
but for
you
the
can't
future.
do it for this, I'm talking tomorrow's.
We do that kind of, we do that thing
No,
for,
I'm
kind of thing in the state for calculating mitigation costs for wetlands that are in the right of way. It's the formula has a real market value of the lot that the impact's on and so forth. Since it's the right of way, it doesn't have a real market value, so we use the adjacent property owners, the real market value of that property as a kind of a sample of the cost of land in that area. So,
Well, I still think it has value to the city, even though they're gonna be taxed later.
Yeah.
You know, you had to buy the property your house is on and you're getting taxed on the whole thing, so
yeah,
I just think it's something we need to look into.
but if you vacate it because for your property, the taxes
That's
will go up definitely.
I understand, but why don't they have to pay for it?
I don't think the taxes go up that much though. I don't think we get that much property taxes.
Based on square footage.
But I think that the slice that the city gets in property taxes, then I don't know, but Patrick might know that better than I do. John told me there's.
So I didn't bother getting the property in front of my house, I just put my flower bed onto it.
Yeah, no. that's
You only
just-
pay more taxes.
It is hard to calculate because real market value, in my experience, is often wrong.
Yeah.
So most often wrong
Yeah,
in county records.
I think ODOT requires an appraisal,
yeah.
To be more accurate.
it's more money.
More accurate.
Then could be a lawsuit and everything else. You know, battle the appraisals, you gotta go.
Well, we have it with the New Jersey we could use.
I'm sure you do.
So do we have any comments
I
on
think
the
that's it.
planning department activity report sent out?
I don't have anything.
Really?
And no proactive items this time?
No, I mentioned some things, so I won't bring up since it's I wrote one up and I gave it and I submitted to Christina and to Jacob and Jenny. And I can send out the outline, the Word document, meaning I kind of have what I think the elements that need to be there. So that, if, you know, Audrey says she has an idea potentially, I mean, the idea is that if a commissioner has an idea, then they can submit it, and then we decide whether we want to take it up or not.
We have those rules, we already.
Yeah, yeah.
So next time we will correct item. Okay.
Be an item, item number one.
As far as the planning department report, this is gonna be the August one, but you may have very recently seen the decision for Port of St. Helens, Port of Columbia County lot across from Pacific Stainless along with Nolte Way. We've been talking with them about this property off and on for years, you know, it's another one of those properties. And within the last couple of years, they've been working with the state on their shovel-ready program. And this application, they don't have tenants. It's still gonna be built based on an actual tenant, but with the land use application, they're that much closer to shovel-ready. So it is kind of speculative. And it was kind of a big application to review based on speculation. But they submitted it and
The nature of the construction is really, it's like a storage unit kind of speculative,
That's what it.
right? So it's not storage, but it's for small businesses to set up their businesses and those things, so you aren't necessarily gonna have it all full when you build it. It's, if you build it, they will come there,
Yeah, it
so.
looked like a strip mall.
And I had to say, I actually permitted the wetland impacts all 5 years ago, so it's been a long time.
But this is an old industrial subdivision, right? And yet you've got new fees for them for traffic impact, all that. Or is that something that was not charged at the first time? I mean, I just read that briefly, that there's some big costs.
yeah, well, I mean, 100,000 square feet of industrial building space, there's a lot of traffic generation resulting from that. And so it's similar to the 4-lot commercial subdivision we did. You know, we didn't require a traffic analysis for that one, but we did, or we have for the uses proposed, like Burger King.
So the shovel-ready planning back in the day, I mean, she was started in 2008 or earlier than that. It was for the whole industrial area, so they planned the kinds of buildings would go everywhere, the size of the lots, to try to get the shovel-ready designation at the state. Delineated the whole properties, had concepts of how to mitigate for the wetlands for all of those developments. And then they scaled it way back to just this one section first. So the big plan, but this is a piece of the large plan. Yeah, all four. That's the rail going into it. This parcel won't be serviced by the rail. It could, I guess.
Parking
But it has a well mitigation site, because they're impacting wetlands. Also avoiding some wetlands along the railroad. And buffers and so forth,
So it signifies two things. One, you know, it's a project we've been talking about for a long time. Two, it's the last spring pileup thing to have been gotten to.
Oh, wow.
Yeah, it's, I got that just at the end of spring. And ever since I got it, all these things, I'm looking at it and going, son of a gun, using different words, of course. Gotta get to the stupid file, son of a gun. And finally, after 60 days, I was able to open it. And finally, it was frustrating. Frustrating spring, but that's spring.
You know, when it's 4:30 for somebody in the morning, I bet they'd like to go to bed.
Hey.
No arguments there.
Yawning.
No, I don't have to leave for another, 3 hours.
All right, I think we can adjourn unless you had something
I
else
think
about
that's a good
that.
idea.
All right.
See you, Russ.
Go get